Hi, everybody. Hope all is well. Welcome to Module 4. Great job this past week with identifying some really important ways to minimize risk in the healthcare setting, particularly with respect to medical negligence claims. And there are a lot of ways to minimize risk. Two key points for me. Number one, there's no way to really eliminate risk, right? I think one thing that we understand from studying the concept of standard of care and the rule related to standard of care is that um, there is a standard. That standard is not perfection. Uh, Certainly, someone who undergoes some sort of medical treatment or medical procedure, things can go as everything can be done perfectly in terms of delivering that treatment or delivering that or conducting that procedure, but things can still go wrong. And so the question becomes, was that service or was that procedure done uh, within the accepted standard of care? And so there's no way to eliminate risk. There are just ways to minimize it. So the second takeaway for me is there are a lot of ways to minimize risk, right? So we a lot of you identified scope of practicing within your scope of practice, which is important. Documentation, which is really important for sure. For me, number one, uh, not to diminish the other ways to minimize risk because they're all very important. They all should be implemented in the practice of medicine or the delivery of healthcare. But really, that developing that relationship with the patient and being transparent and having open communication is really important in minimizing that risk. So when we think about risk in your own practices or in your own work or as in your future endeavors within the healthcare industry, think about that. Think about the importance of developing that relationship with the patient, being open, being honest, communicating, being transparent. Um, I've seen it dozens of times where it's, uh, a lot of times a patient, if something goes wrong, then this doesn't mean that there's negligence or liability because you still have to show all four of those elements. But if something goes wrong, um, a patient may be more likely to sue or to file a lawsuit or make a claim if there's a really poor relationship there. I think that's really important. If they're not able to work things out, if there isn't open and honest communication, a good relationship, I think that risk goes up. And I've seen it, and I'm sure many of you who are clinical practitioners have seen that as well, and the importance of that. So, enough of that. We're moving on to Module 4. This week, I want to talk about medical records a little bit. The discussion question this week in Module 4 is my favorite one because it really forces you to think through what we've been discussing, which is how to conduct a legal analysis. And um, and I'll get into that before I finish this video. But before we get there, medical records laws and rules, there are two levels. There's the federal level and there are state level. So when we think about the federal level, we obviously our first thought goes to HIPAA, which is correct. And there are other laws that are specific to like mental health records, psychotherapy records, which we're not going to really get into, substance abuse disorder, medical records, but HIPAA we're gonna talk a little bit about because it pertains to our discussion question this week. The HIPAA is really broken down into three different rules. It's broken into the privacy rule that governs proper, improper uses and disclosures of protected health information. The security rule, which really deals with the safeguards, your administrative, technical, and physical safeguards to secure protected health information, and the enforcement rule. You can go online to the Office of Civil Rights website, which is the arm of the Department of Health and Human Services that enforces HIPAA, and they publish all their enforcement actions for breaches, for for sizable breaches, failure to follow policies, failure to make timely notifications of breaches to affected patients, all sorts of things. And those penalties and sanctions can be very sizable, in the millions of dollars. And there's a criminal component as well, depending on how egregious the facts are in a particular breach. But the privacy rule, as I mentioned last week, with few exceptions, give patients the right to inspect, review, and receive a copy of your medical records and billing records. They're held by what HIPAA calls covered entities, and covered entities, that's defined as healthcare providers, healthcare plans, and healthcare clearinghouses. And so I mentioned last week, HIPAA is really big on patient rights. And so the right to access, whether it's you, the patient, or your personal representative, right to amend, right for an accounting of uses and disclosures of your protected health information. Those are mandatory. Those are times when it's mandatory for a covered entity to disclose the protected health information to you as a patient. The other exceptions are permissive. They allow you to allow the covered entity to disclose or use protected health information in certain situations. So that's the federal law. So the state laws regarding medical records, there are state laws. There are state privacy laws. You may be familiar with really the biggest state privacy law that's really taken the data privacy world by storm, which is in California, the CCPA, and those are very restrictive laws in California, and I really think those state laws are going to proliferate through other states, and within the next 10 to 15 years, you're going to see a lot of states have very restrictive state privacy laws. But state privacy laws really govern things like how long do you have to retain your medical records. It's a misconception in the healthcare world that HIPAA has a data retention requirement of 6 years. That's incorrect. What HIPAA does is it requires you to keep all your HIPAA documentation for 6 years. So that includes any like business associate agreements, any HIPAA training materials, any HIPAA authorizations signed by patients, any HIPAA materials like that. They have to be retained for at least 6 years. The medical record retention laws are really governed by states. So for example, I used to practice law in Kansas, which it's been a while, but I think the medical retention law there was 15 years. Others, it's 10 years. In Arizona, it's 6 years. I do a lot of work in Arizona. So it just varies from state to state. So it's really important as a medical provider, to know what the laws are in that particular state. And there are certain notice obligations. So if you close down a practice, for example, you may be required to provide notice. In fact, most states are required to provide notice to the state health agency, also to the patients, so they can know if they want to access their records, how do they do that, and where do they go to get those records. So that's I think that's important. There may be state laws regarding privacy of medical records that overlap with HIPAA, and so HIPAA will always preempt state law unless the state law is more stringent, meaning it's more restrictive. So if the state law is more restrictive, that is the law that will apply. But if it's not, then HIPAA will preempt, meaning it will basically supersede that state law. So the discussion question this week is interesting to me because it asks you to analyze two different scenarios in which somebody discloses some personal health and protected health information. And it asks you whether there was a breach. So, I think there are two ways to attack this. The one way a lot of people attack it is sort of just intuitively thinking, oh yeah, that's got to be a breach because of X, Y, and Z. The right way to attack this is to think through this analytically and conduct a legal analysis. So when we think about legal analysis, we think about going through that IRAC method of legal analysis, the IRAC: issue, rule, application of facts, and conclusion. So what's the issue? The issue is whether there was a breach or not. And what's the rule? Well, the rule is going to be found in the definition of breach. And I'll post something for you, but you can certainly search it online. How do you define breach in HIPAA? And there is a regulation that defines breach. And what you'll find is that to determine whether there was a breach requires an analysis of the facts, meaning just because somebody improperly used or disclosed protected health information, that doesn't mean it's a breach. The definition of breach provides multiple factors to consider, including some exceptions. There are some exceptions in the definition itself of when it's not a breach. So those are things that really need to be considered. So it's important to utilize that rule in analyzing this discussion question. What is a breach? Apply the facts that are given to you in the discussion question, and then come out with your conclusion. Issue, rule, application of facts, conclusion. The same process that you're going to use to analyze the legal components in the Ituraldi case for your milestone project. What are the elements of negligence? There are 4, right? The duty, breach of that duty, causation, and damages. What are the rules for each one of those? Go through that process for each one. That's important because the absence of any one of those elements means there is no legal negligence. That's all I have for you this week. So again, please feel free to reach out if you have any questions. Please think through this discussion question carefully. It's good practice. It's good practice on conducting a legal analysis, and really think about that rule, the definition of breach, and how that applies to the facts that are given to you in the discussion question. So I hope you all have a fantastic week. I am here if you need me. Please feel free to reach out. I know some of you have reached out with questions about assignments, and I love it. Please do it. Again, my main objective in this class is for you to get value out of it. That is what I want to do. So whatever I need to do to make that happen, I'm willing to do it. So have a great week, and hope it's a great one. Take care.